So this is just We the People News. Okay, this video is without prejudice and or without recourse. Okay, I'm not an attorney. I'm not giving legal advice whatsoever. People may or may not be in my opinion, but this video is also just opinion and a learning video. Okay, so do not misconstrue this as any type of shape, form, or fashion of legal advice. People, okay. Alrighty. This is with Colin Miller. That being said, I do not know a whole lot about Colin Miller. I don't know what divide is involved with him. However, I do know one thing. If there is a divide against him, then who's the one that really lies to you? If attorneys and judges and all that said he is incorrect, well, aren't they the ones lying to you anyway? When they, in fact, are violating your due process without letting people know that when an officer arrests you without a warrant to be taken directly to the magistrate before jail. That way a magistrate or a judge can determine the probable cause before an innocent man is in a cage. Okay? So, remember, an officer, a cop, sheriff, whatever, cannot make legal determination. So even when a cop says there's probable cause, he just made a legal determination. He's not even allowed to do that, people. That's the reason why he must go get a warrant before even taking you even to the magistrate. That right there is conflict of interest. That's denial of due process. But at the very minimum, if you see that he's going to push, then push back, demand 3. I say 3 times because that's what normally things are. But demand it the whole entire time you are in his seizure, his custody, his control, his arrest. Okay? Remember, any type of seizure is an arrest. That's a stop. You are not free to move freely. Alright. Let's go ahead and proceed forward on this.
Constitutional Law by Carl Miller. Your Constitution is an ironclad contract, enforceable in a court of law. U.S. Constitution, Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The Supremacy Clause of the U.S. Constitution. U.S. Constitution, Bill of Rights, Article 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. U.S. Constitution, Bill of Rights, Article 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. U.S. Constitution, Bill of Rights, Article 4. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. U.S. Constitution, Bill of Rights, Article 5. No person shall be held to answer for a capital, or otherwise infamous, crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service, in time of war, or public danger, nor shall any person be subject, for the same offence, to be twice put in jeopardy of life or limb, nor shall be compelled, in any criminal case, to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law. nor shall private property be taken for public use, without just compensation. U.S. Constitution, Bill of Rights, Article 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Constitutionlaw 19 U.S. Constitution, Bill of Rights, Article 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact, tried by a jury, shall be otherwise re-examined in any court of the United States than according to the rules of the common law. U.S. Constitution, Bill of Rights, Article 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. U.S. Constitution, Bill of Rights, Article 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. U.S. Constitution, Bill of Rights, Article 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Laches. Doctrine of laches is based upon maxim that equity aids the vigilant and not those who slumber on their rights. Neglect or omission to do what one should do as warrants presumption that one has abandoned right or claim. Eldridge v. Idaho State Penitentiary, 54 Idaho 213, 30p.2d 781, 784. A failure to do something which should be done or to claim or enforce a right at a proper time. Hutchinson v. Kenny, CCANC, 27f.2d 254, 256. Marbury v. Madison, 5 U.S. 137, 1803. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical, for certainly, the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict would be null and void of law. It would bear no power to enforce, it would bear no obligation to obey, it would purport to settle as if it had never existed, for unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a mere nullity or a fiction of law. If any statement, within any law, which is passed, is unconstitutional, the whole law is unconstitutional. By Marbury v. Madison. Shepard's citations. A group of reporters that go through and keep track of all court cases that have come before the courts, especially the Supreme Court, and they clarify, before the court, all the cases. All cases which have cited Marbury v. Madison case, to the Supreme Court has not ever been overturned. See Shepard's citation of Marbury v. Madison. Constitutionlaw 29. Title 5, U.S. Code Sector 556, D, Sector 557, Sector 706, courts lose jurisdiction if they do not follow due process law. Title 18, U.S. Code Sector 2381, in the presence of two or more witnesses of the same overt act, or in an open court of law, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason. Notes. Title 18, U.S. Code Sector 2381, in the presence of two or more witnesses of the same overt act, or in an open court of law, If you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason. Title 18, U.S. Code Sector 2381, in the presence of two or more witnesses of the same overt act, or in an open court of law, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason. American Jurisprudence Book 16, Constitution Law Section 16 AMJR 2D 16 AMJR 2D, Sector 97. Then a constitution should receive a literal interpretation in favor of the citizen, is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to person and property. Bay v. United States, 273 U.S. 128. Any constitutional provision intended to confer a benefit should be liberally construed in favor in the clearly intended and expressly designated beneficiary. You are the beneficiary of the U.S. Constitution. 16 AMJR 2D, Sector 98. While an emergency cannot create power and no emergency justifies the violation of any of the provisions of the United States Constitution or states' constitutions. Public emergency such as economic depression for especially liberal construction of constitutional powers, and it has been declared that because of national emergency, it is the policy of the courts of times of national peril, so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and in so far as may not be clearly inconsistent with the Constitution. No emergency has just cause to suppress the Constitution. 16 AMJR 2D, Sector 114. As to the construction, with reference to common law, an important canon of construction is that constitutions must be construed to reference to the common law. The common law so permitted destruction of the abatement of nuisances by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle, and although there is no common law of the United States in a sense of a national customary law as distinguished from the common law of England, adopted in the several states, in interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood. 16 AMJR 2D, Sector 117. Various facts of circumstances extrinsic to the Constitution are often resorted to, by the courts, to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. 16 AMJR 2D, Sector 155. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions irrespective of their opinion as to the wisdom or the desirability of such provisions, and irrespective of the consequences. Thus it is said that the courts should be in our alert to enforce the provisions of the United Constitutionlaw for 9 States Constitution and guard against their infringement by legislative fiat or otherwise. In accordance with these basic principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into question. If the Constitution prescribes one rule and the statute be another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. 16 AM JER 2D, Sector 177. Declaratory judgments actions have often been utilized to test the constitutionality of a statute in government practices. The Uniform Declaratory Judgment Act makes specific provisions of the determination of construction or validity of statutes and municipal ordinance by declaratory judgment and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statute and of ordinances. The Federal Declaratory Judgment Act, although it does not mention declarations as to the construction or validity of the statutes, has been invoked.
Remember, ordinance by American jurisprudence is for the corporation, McDonald's, not the people.
Frequently as a means of assaying of the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge so long as he does not ask to have the operation of the statute enjoined. A court may grant declaratory relief, unless there is a case of controversy before the court. No one is bound to obey an unconstitutional law, demand a declaratory judgment. 16 AM JER 2D, Sector 255. In all instances, where the court exercise its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. Thus a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. A clear incompatibility between law and the Constitution must exist before the judiciary is justified holding the law unconstitutional. This principle is of course in line with the rule that doubts as the constitutionality should be resolved in favor of the constitutionality and the beneficiary.
Alright. Peace of weed, people news. Bye, y'all.